This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fenske. A WashU professor faces criminal charges for touching students inappropriately. A St. Charles County judge is being forced into retirement for dressing up like Elvis. And a man faces 17 years in prison for his hostile Facebook posts about a local police officer. These are all headlines from the past few weeks, and all of them involve the judicial system. And so today, 3 top attorneys join us to help make sense of how we got to this point and what could happen next. Yes, today is our Legal Roundtable, and this month we are pleased to welcome Eric Banks. He's a former city councilor for the city of St. Louis, and he is now an attorney and mediator at Banks Law. Eric, welcome.
Thank you. Thank you very much.
And we're also joined today by Dave Rowland. He's the director of litigation at the Freedom Center of Missouri. Dave, welcome.
Thanks so much, Sarah.
And always a treat, today we're joined by Jennifer Joyce. She was the St. Louis Circuit Attorney from 2001 to 2017. She is the founder and now a strategic advisor for the consulting firm Vera Causa Group, LLC. They work with prosecutors around the country in areas such as communications, leadership, and racial equity. Jennifer, welcome back.
Glad to be here.
So Jennifer, I'm especially happy you're here today because I love to be able to pick your brain on matters related to criminal justice. And we're going to lead off with one of those right now. This is a high-profile misdemeanor case. You don't always hear those two words together. It came to an abrupt end this month. The circuit attorney's office had spent the last 2 years pursuing charges against the owner of Bar PM. This man reacted angrily when police crashed their SUV into his bar. Chad Morris faced a misdemeanor charge until Judge Rochelle Woodiest threw the case out this past month. Judge Woodiest seemed to be responding to allegations that prosecutors had failed to turn over critical evidence. Prosecutors, meanwhile, said they turned over everything they got from police. They just didn't get everything that defense attorneys thought they should have gotten. This seems like such an unusual case in so many ways. Jennifer, I'm wondering what strikes you looking back on this?
Well, I do think it's an unusual case. It's definitely not your run-of-the-mill. Anytime you have a police officer crashing his car into somebody's establishment, that's unusual right there. But what's not unusual is not getting information from the police that you need to turn over. I've seen that happen in the past. They have different rules as to how they handle their personnel stuff, and they may not feel that they need to give certain things over. But the prosecutor is the quarterback, and they're responsible for that. And sometimes the remedy is to dismiss a case. But the circuit attorney, Mr. Gore, felt very strongly about this case. And I know that you and some others felt that, why are we prosecuting this?
I believe I am on the record asking that question. So
yes, and you're not alone. I mean, there are other people who, particularly in that community, who have spoken to me about it. I guess we would all be mad if we had a business and the police crashed their car into it. The question is, he wasn't just mad, he pushed an officer, okay? And a lot of times people may say, well, a push is no big deal. Well, that poor officer up in Ferguson who's still recovering, that was a push.
That's true.
Okay, so these, where do we draw the line there, I believe, and, I think he's made it clear, and he's told me so, that he felt very strongly, Mr. Gore, that it can't be the rule that just because you're upset, you get to assault a police officer. That can't be the rule. And he was concerned that if he did not prosecute this case at a low-level misdemeanor, that he would be sending that message that as long as you're really upset, then go ahead. And as I always say, discretion is the prosecutor's superpower. They get to bring cases or not bring cases at the state level as basically as fits with their idea of how they can best serve the public. And I think he felt strongly that that would be sending a message that would not serve the public. And he also has said, and this is something that in the possession of the police department, that there's a body camera video or a dash camera, some kind of video is in the possession of the police department that I'm told will illuminate this so much more as to why they felt the charges were required here.
It's interesting. You know, Gabe Gore is, I think, very popular in the city. I remain a city resident, and I hear from my neighbors that people are just so impressed with how he's sort of brought the office back. After Jennifer left, there was a few years where things seemed to not go as well as they did when Jennifer was there. And, you know, Gabe Gore has restored a lot of respect for that office within the community. It certainly would have been easier for him to drop this case. Residents would have been like, yep, you know, he's finally done what we thought he should do. Eric, what do you make of what Jennifer just outlined here?
I disagree with the prosecutorial discretion that was used in even issuing the case. I don't think the case should have been issued. Back when I was a circuit attorney, a very large percentage of cases were taken under advisement, TUA'd. And I thought that if there was ever a case that was deserving of a TUA, it was this case.
What do you make of that argument that if we didn't prosecute somebody for shoving a police officer, pushing a police officer, you're sort of opening the gauntlet where we would all just go around pushing police officers?
Well, that's a valid point. I don't have any argument with that.
Yeah. Dave?
Yeah, so I'm with Eric on this. I think that, sure, there's a valid point that, you know, we do not want citizens feeling like they're entitled to shove police officers, even if the citizen feels like they've been wronged. On the other hand, the facts of this situation are really unusual, and especially given some of the information that we don't have, like were the officers involved potentially under the influence of something, which we don't know because there doesn't appear to have been any blood toxicology report made. You know, I think that makes for a set of facts that is unusually tilted, I think, in favor of just not bringing the charges in the first place. But I am glad to see that the charges now have been dropped.
Eric?
And in addition to that, we don't know what happened before the pushing took place. The officer may have said something indiscreet that the person took as a provocation and just lost it. So
that's why I think it's good to see that video. I mean,
yeah.
If we're going to start going down the road of we don't know what happened before that, Martians could have come down and, there's all kinds of stuff. I would love to see this video. I'm told it's very illuminating. I have to say, probably 7 out of 10 prosecutors would not have pursued this case. It is. In many ways, I agree with Eric and David that this is one where it's kind of a unicorn. And what is going to be the precedential value of this? But what I wanted to do this afternoon, is tell you what the thinking was behind charging it and why it was like the hill he was going to die on.
Yeah. And I imagine hearing that sort of thinking outlined, I bet there were some police officers saying that to him, as much as we're all talking amongst ourselves saying we know people in the LGBT community who were really upset about this. Police were maybe upset in a totally different way. Dave?
Well, and one thing to follow up, Mr. Gore's predecessor, I believe, had made a point of conspicuously not backing police officers, at least certain police officers. And I think that potentially drove a wedge between the police department and the prosecutor's office. And with this incident coming fairly close on the heels of Mr. Gore taking over the reins, perhaps he viewed that as an opportunity to show good faith, that he wanted to support the police department to the extent that he felt like was supportable and feasible. But maybe it was still the right decision to drop the charges after that initial stand had been made.
Yes.
Well, I will say they're not appealing it.
The order dismissing the case. They've decided to let that stand.
They're not noticing up the police for a hearing to force them to provide stuff. It's done.
It's done. And maybe St. Louis should be happy about that. As you're here listening to our panel, you may have a question or comment about this story or what else we're discussing today on this August Legal Roundtable. You can give us a call at 314-382-8255. That's 314-382-TALK. Jennifer, we were just chatting about the fact that Circuit Attorney Gabe Gore does seem like he's very hands-on in a way that his immediate predecessor wasn't always perceived that way. to the point that he goes into court. He is himself prosecuting some of these cases, not just supervising people who did.
Yeah, I think that's very commendable. It's also unusual in jurisdictions of this size to have the elected prosecutor go into the courtroom and carry a caseload. In smaller jurisdictions, yes, the elected has a caseload like anybody else. But in larger ones, it's typically not done. The only one I can think of off the top of my head is the Tulsa guy tries cases every now and then. But Mr. Gore, to his credit, I think he recognizes that even though he was a prosecutor, he was in the federal system. And the federal system is night and day different than the state system. Different jury pools, different rules, different laws, different everything. And he wants to experience the state system. And so he has had these 10 cases assigned to him. I think he has attorneys working with him, but he's doing everything, himself. And I think it's admirable. I was not able to do that when I was circuit attorney. I tried a couple of times, but the demands of the job and the unpredictability of the job got in the way of it. And so and it got to the point after a couple years, I'm sure Eric and Dave will agree with me, that being a trial lawyer is like speaking a foreign language. If you stop doing it, you start to get very rusty. And so I might have a lull, but I've been 5 years without trying a case.
Yeah.
And what poor victim is going to get rusty old me instead of one of my virtuoso prosecutors that are in court every other week? So I let that go. But I came up in the state system. I tried a bunch of cases before I got elected, so I didn't have that urge to do it that Gabe does. Yeah. And I just think it's very admirable because it's tough to do. Yeah. It really is.
I think even outside the law, we all respect a boss who knows how to do the job that the underlings have to do.
Right.
That's a better boss.
I think it's probably very inspiring for the troops over there to see that.
Yeah.
When I was the city councilor, I had 4 attorneys who were assigned to the labor and employment section. One of them went on maternity leave. So I said, I'll take her cases because the office is already understaffed, underpaid, so on and so forth. And there was a significant amount of pushback from the staff about me accepting this responsibility. And basically, I was told, well, whenever you try a case, you better have a second chair sitting right there who knows as much about the case as you do, so that when the mayor's office calls and says he wants to see you, right now, that second chair can just step in and seamlessly take over.
And is that how it worked? Yeah, there were times you had to not be there for a court hearing when it was your case.
No, it didn't, but it could have.
It could have, yeah. Well, it's good your staff was there to give you that second chair support. I want to talk about another misdemeanor case that was filed recently, but this one by the St. Louis County prosecutor. This involved 3 Class C misdemeanor charges against a Wash U chemistry prof. He's accused of touching 2 unnamed victims in the lower back and thighs. The charges say that Professor Jonathan Barnes knew the touching would be taken as, quote, offensive and provocative. Now, we've all accidentally sort of brushed past somebody. We might touch their lower back or their thighs. That's not criminal. But if we're doing it knowing it's offensive, Jennifer, that's a different story.
Yeah, I think that every crime has an action and a mental state. And in this case, if it's done for sexual purposes, it's a little bit of a higher charge than if it's just done in an offensive fashion. And this is, I know one of the things people may be asking is, well, in this case, how can you prosecute a case where it's just he said, she said?
Yeah, there's never going to be any evidence, like DNA evidence, ever of the back touch.
Let me tell you something for you and other jurors out there, potential jurors. Testimony is evidence. Okay, so that's evidence just as much as DNA or anything else. In fact, you can have a case with just testimony. When I started being a prosecutor, we didn't have DNA. I mean, we had DNA, but we didn't use it as evidence.
We didn't really know we had DNA.
We didn't think about it. So it's not uncommon for he said, she said in all kinds of cases. A little old lady gets robbed at gunpoint in an alley and they take her purse and run away. There's no DNA. There's no video. There's nothing. It's the little old lady saying this is the guy that did it. So on this case, though, I think and I don't know anything about it. I haven't read the charging documents, but I do know that this is a prosecutor, Melissa Price Smith, who has extensive experience in this type of crimes.
This is her specialty.
Exactly. And I can't believe that she would bring this if she didn't have what she felt to be a strong case. And I think she has a very educated opinion about what's a strong case. So whether there's multiple victims or what have you, but ultimately the fact that there's no DNA or anything is not a hindrance.
Dave?
Yeah, I wanted to comment on the fact that it's really unusual to look at it from kind of a contemporary perspective and have such a high expectation of what kind of evidence might be brought to bear when our entire legal system developed before we had a lot of the tools, the forensic tools that we have nowadays. And this is what the function of a jury was.
Right.
It was to hear different people describe the circumstances of an alleged crime or a tort, and the jury had to decide, who do they believe? And do they believe that story beyond the applicable standard of proof? And so I think that one of the issues in this case is likely to be, even if you can persuade jurors, okay, maybe this professor did inappropriately touch these students, do you believe it beyond a reasonable doubt? Mm-hmm. I think that may be a difficult burden to clear for the prosecution. But if they do, again, that's why we have juries. Jury's job is to make these sorts of determinations.
Yeah, boy,
Amen.
I would hate being on this jury. I feel like you're going to have really compelling people on both sides, and you're going to be whipsawed going back and forth.
But that's why juries are so important.
Yeah.
And that's why it's important that people embrace jury duty and understand the importance of that role in our legal system. It's the crucial point where citizens have an opportunity to play a direct role in the way that justice is administered in our society. And that's a wonderful thing, even at the same time as it could be very intimidating.
For sure. Eric?
And the haters would say that juries are all about choosing which lawyer they like the least. And so you shouldn't deprecate the value of not only direct examination, but cross-examination as well. Because I've sat in on some trials where the defense attorney just ate the prosecutor's lunch, just tore his witnesses, her witnesses apart. So you can't tell what's going to happen.
Yeah. Do you think this one is headed for a jury? It seems so unusual to have a misdemeanor case that would not just, they'd find a way to settle it.
Well, I believe all cases should settle anyway.
I do know this about you, yes.
What I can't wrap my head around is there's 3 victims, and I don't think all 3 of them conspired to tell the same lie.
Right.
I mean, that's
That would be
tough defense. I think that it's going to be a jury trial. That's my guess, because even though it's a misdemeanor, there's a lot at stake for this professor.
He has so much to lose.
And there must be some kind of evidence that is compelling for the prosecutor bring this case with her experience. She's not new at this. She's not just throwing something up at the wall to see if it sticks. She knows she's got a shot here, and she's taken her shot, and he's got a lot to lose. So that's why I think it's going to be a jury trial.
So one unusual wrinkle here, Dave, I'm going to direct this one to you since you're a civil guy, not a criminal law expert. Before he was charged with these misdemeanor criminal charges, this professor had sued Meta, the parent company of Instagram, to try to unmask the identity of anonymous accusers who'd sort of put this out into the social media ether. And Judge Joan Moriarty had agreed he should have some of that info. She was saying that should be turned over. And then that same day, these criminal charges dropped. Do you think he could possibly have any sort of defamation case against these anonymous accusers if he ends up winning this jury trial?
Well, he possibly could, but again, defamation is a pretty high bar to clear too. Now, I mean, what he would basically have to do is be able to, in a civil case, show beyond a preponderance of the evidence that these claims about him were false, and depending on whether the court decided that he was a public figure or not, maybe he'd have to show that they were maliciously false. So, sometimes people take offense when others might not expect them to. But if them simply saying, "Hey, I was offended by the fact that he did this. I felt, I felt what's the term I'm looking for? I'm sorry. Words are failing me today in a way that they usually would.
Yeah.
But basically, if you feel like you've been improperly touched, that doesn't necessarily imply that you are saying this maliciously trying to harm or impugn the character of the person who touched you.
Maliciously would be if you knew in your heart it was completely false, and you got your friends together and got a prosecutor to do it anyway.
Right, and I'd be surprised if a court found that a university professor was considered to be a public figure, but some university professors might indeed be considered public figures based on the extent to which they inserted themselves into public issues or commented on public issues. I don't know this particular professor, so I can't speculate about.
He's no Larry Summers. I think he's probably a public figure.
Right.
Harder path.
But yeah, I mean, I don't know whether if I'm advising somebody in a case like this, whether I would say, oh yeah, I think you've got a decent shot at winning, or whether I'd say, maybe you're just not going to win this one.
Yeah, you've got enough of a fight on the criminal side.
Right.
If I were my client, I'd advise him to think about not filing a suit against the accusers and just letting this go.
Yeah.
I mean, he might have still been charged by the prosecutor. I don't know what the timing was, if that was a coincidence or what. But, I just think the more you do that, I mean, we saw that state senator in Missouri did the same thing. He sued his accuser, and it creates a whole new news cycle.
It sure does.
Well, one of the other factors involved is if you have filed a civil suit for defamation, you are also then subjecting yourself to discovery. And that means that they can ask about all kinds of allegations that may have been raised against you in the past. And for a lot of people, even if you feel like you're completely innocent of any wrongdoing, that could still create for some very uncomfortable situations.
Mm-hmm.
We're talking today to our legal roundtable. That is attorney Dave Rowland. We're also joined by Jennifer Joyce and Eric Banks. We need to take a quick break. When we come back, we'll talk about a judge who's now in some hot water. This is St. Louis on the Air on St. Louis Public Radio. Welcome back to our monthly Legal Roundtable. I'm Sarah Fensky, and today I'm joined by three top attorneys. That includes Dave Rowland, Director of Litigation at the Freedom Center of Missouri, Jennifer Joyce, the St. Louis Circuit Attorney from 2001 to 2017. She's now a strategic advisor for the consulting firm Vera Causa Group, LLC. And last but never least, joined today by Eric Banks, a former city councilor for the city of St. Louis. He's an attorney and mediator at Banks Law. A St. Charles County judge had to face the music this month. Missouri's Commission on Retirement, Removal, and Discipline of Judges wants a little less conversation after Judge Matthew Thornhill dressed up as Elvis in the courtroom, complete with a wig, and the judge even made jokes about Elvis to litigants. People also told the commission that Thornhill played Elvis songs on his phone in the courtroom. Sounds familiar, huh? He is now being forced to retire, but it's an unusual deal. He's getting a 6-month unpaid suspension, then he gets to return for 18 months, but only with an ironclad agreement that he will retire at the end of that time. That is the recommendation of the Commission on Retirement, Removal, and Discipline of Judges. Eric, do you think they threw the book at him, or do you think they let him off easy?
I think that they issued discretion, and I don't think he was let off easy, but I don't think that the punishment was excessive as well. I think of some of the indignities that I have faced in courtrooms recently, and yes, I do believe it was a result of my race. And I just cannot imagine what would happen to me if I showed up in his courtroom or somebody like his courtroom dressed up as Elvis or anybody else. So I think that this is more than a slap on the wrist. I don't think it's excessive. I hope it sends a message to all the judges throughout the state of Missouri.
So my understanding of reading the file on this, it sounds like he only dressed up like Elvis once on Halloween, but he was continuing to do this Elvis shtick all the time in court. Can a judge not let their hair down at Halloween?
Nope.
Nope.
Not during
simple.
court, not when court is
Okay.
in session.
He said he wanted to make the litigants just feel a little more comfortable and at ease. What do you think of that, Jennifer?
I think he'd make them feel much more uncomfortable by pretending to be Elvis during a court proceeding.
Dave?
Yeah, I think that one of the things that's important for the judiciary is for the parties before it and also the public to feel confident that the judges are taking their roles seriously. And so, sure, you could be able to write this off as, well, just wanted to inject some levity into the circumstances. But being in front of a judge is not a circumstance where you really want a lot of levity.
No.
You want to be confident that they understand their role and that they are exercising appropriate discretion as they're fulfilling that role. I've never had a judge wear a costume when I was in front of them, but I can say that if that ever happened, I would have some pause about whether the judge was taking the matters or their role as seriously as I would like them to do.
Eric?
And what's that old saying about being as sober as a judge?
Right.
I mean,
Excellent point.
I've had potential clients complain to me because their former attorney shook hands with the other side. People expect a certain amount of seriousness, decorum, respect, and I think that the good judge's behavior crossed the line.
So, all of us in the news media, we love an Elvis story. We love to get into something that's funny. There's not enough in the news that's funny some days. But there was a whole other aspect to this in addition to the Elvis stuff. And that is that he supposedly talked to people about his election campaign. He'd sort of make comments that had to do with the politics of various people to the litigants. And then a day after there was media coverage of this recommendation by the commission, the Judges Commission, the Post-Dispatch had just a terrific scoop that got into an even more troubling allegation. Somebody had clearly tipped them off to this after seeing about the Elvis stuff. They wrote that the judge had been assigned a case involving the St. Charles County Republican Party. He called its chairman to ask for his opinion. This is a Republican judge. This is obviously someone he was friendly with. He calls him and asks him about this case where the guy could end up being a party to this case, could have been called as a witness. To me, that feels like a really big deal. Dave, is that a big deal?
Based on the allegations, it certainly seems like a really big deal. I hesitate to comment on it because it doesn't appear that this was part of the recommendation that was being made by the Ethics Commission. And I do think there's a fair question as to why. If this information was available, why would it not have been addressed as far as the Ethics Commission and its recommendations? So I think it certainly raises a number of interesting questions.
Jennifer?
So what the general rule is that in a litigation, the judge is not supposed to go off and do their own fact-finding. They're supposed to make their decision based on the evidence in front of them. But they're especially not supposed to go out and talk to other people involved in the case without both parties being present.
Yeah.
It's called ex parte. And, so regardless of what stage the litigation was at, if he's talking to other people about the litigation without both parties being involved, it's not a good look.
Do you think it's a bad enough look that it could end up blowing up this whole deal, where he gets to come back for 6 months and then, gets to serve for another 18 months in order to get his full retirement?
I don't know how to call that one. We'll have to see.
Eric?
This is a classic case of why I'm in such favor of the nonpartisan plan for selecting judges.
I'm glad you brought that up. So in our bigger counties, including St. Louis City, St. Louis County, our judges are chosen in a way that it supposedly encourages a higher candidate of person, because they won't have to run for office, really. They just have to run for a retention vote. St. Charles County, even though it's so fast growing, they're not a part of that.
No. I will say judges are human. Okay, so they have all the strengths and weaknesses of any human being. And my career was spent in the city, in the 22nd Judicial Circuit, where we did have the nonpartisan court plan. And I had one judge who never paid his taxes, and he was referred to prosecution to me. I had a judge that was, suffering from addiction issues. I mean, there's all kinds of things that can happen. I think the point here is, and in those cases, in the nonpartisan arena, and in this case, in St. Charles, in the elected judges arena, there are safeguards here that will step in and review these things. We may not agree with the decisions that they make, but I think the judiciary does a pretty good job of policing itself, partisan, nonpartisan court plan.
Yeah, that's what we're seeing by this commission. They are proactively wading into this mess. Dave?
So one of the other elements when you have partisan elections is it also necessitates a campaign for those elections. And one of the bits of information that I don't think has been mentioned is that the Republican Party official that the judge reached out to was actually his former campaign manager, or rather former campaign treasurer.
Yeah.
And so the personal nature of that relationship and how closely tied it is to the fact of the judge's tenure on the bench, I think raises some certainly uncomfortable questions. The kinds of questions that ideally we wouldn't need to ask about someone who is serving presumably in an impartial role on the bench.
Yeah, I think you're right. I think it's all very troubling, and I'm going to be very curious to see what happens here, if the recommendation from this commission is taken up, if this news story by the Post-Dispatch changes anything. This may not be the last time we're talking about this. I am going to go to the phone lines here, and just a reminder, if you have a question or a comment for our panel on the legal matters we're discussing, you can call us at 314-382-8255. That's 314-382-TALK. We're going to go back briefly to the bar PM matter that we discussed. I know Alan is calling from Kirkwood and wanted to share a few thoughts. Alan, hi. You are on St. Louis on the Air.
Thank you. My thoughts about this case from the beginning, and I'm a former prosecutor from a million years ago in the county, is that the police story changed multiple times right at the beginning of this thing. Mm-hmm. Something about a dog running across the street and all this other stuff. And I think that those factors should be an important part of the context in which the state reviewed these facts and decided whether or not a charge should be issued. It seems to me that it's really a big issue about police misconduct more than it is whether or not the charged defendant push the police officer.
Alan, thank you for that. I'm curious, Jennifer, if you have any take.
I totally see what Alan is saying. However, you can deal with these issues separately. There could be police misconduct here that is not pertaining to the push, the assault. It was a different officer that crashed his car than the one that was pushed, allegedly pushed, I guess, at this point. You can have one and the other. I think that the analysis that Mr. Gore has for the push, he would hang on to that even though he knew that there was some changing story and some weirdness with the police behavior with respect to the car accident.
Yeah, I should say, though, then the police officer who said that he was pushed, this guy had a track record that was extremely troubling. He had a history of overreacting to citizens. And so it is all a messy stew. I do not envy the job of prosecutors. But, Alan, thank you for that comment. We appreciate that. And you know what? We're going to have to take a quick break here. We're talking to our legal roundtable. That is former St. Louis Circuit Attorney Jennifer Joyce. We're also joined by Dave Rowland of the Missouri Freedom Center and Eric Banks of Banks Law, LLC. Coming up next, a man in St. Charles County faces more than a decade in prison over his social media posts. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. We'll return to that conversation in just a moment. First, we'd like to ask for your help ahead of tomorrow's show. As you prepare food and festivities for Thanksgiving and other holidays coming up, you might also be bracing for complex and often fraught family dynamics. Is something causing you stress as the holiday season approaches? Have you had to set boundaries with certain family members? Or perhaps financial strain is affecting your ability to enjoy the festivities? A licensed clinical psychologist will join us tomorrow with advice on navigating tricky situations. Share what's on your mind with an email to talk@stlpr.org or leave us a voice message by calling 314-516-6397. That's 314-516-NEWS. You can even remain anonymous if you wish. And now back to our panel, which is bravely not anonymous, sharing all their opinions on matters of law and also their expertise. Today, that panel includes Dave Rowland, Director of Litigation at the Freedom Center of Missouri. We're also joined by Eric Banks, a former city councilor for the city of St. Louis and an attorney and mediator at Banks Law, and Jennifer Joyce, who was the St. Louis Circuit Attorney from 2001 to 2017. She's now a strategic advisor for the consulting firm Vera Causa Group, LLC. So, Dave, a St. Charles County man was found guilty of harassing and stalking a local police officer. And this feels like maybe a free speech case. Matthew McNeenamy, I think I'm saying that right, accused a St. Charles County police detective of being racist, of domestic assault, and violating McNeenamy's civil rights. And he did this using social media posts, flyers, even a website he put up to come after this officer. So the man's attorney, this is Randall Wiest, he said, quote, "The state is trying to send Matthew to prison for his Facebook post, for his comments. This case is not about whether what he posted is right, but whether he has the right to say what he did on his Facebook page." The jury didn't seem to agree with that take. They recommended that this guy should get 17 years. He won't be sentenced until January. But in the meantime, do you think there is a free speech issue here? Do you think his lawyer got this right?
Well, let me clarify a little bit, just to the best of my understanding, procedurally how we got here. I believe that the defendant's attorneys filed a motion arguing that the statements and the flyers and the postings that were the basis for these charges were speech protected by the First Amendment, and that therefore the prosecution should be discontinued. The judge disagreed with that. So that was a ruling on the constitutional question. And then the question went to the jury about, did he actually do what was accused? And the jury came to the conclusion that he did, and they have recommended the charges. I actually just looked up the verdict form that the jury submitted, and so there were 4 different counts, and they recommended imprisonment for 4 years for count 1, imprisonment for 4 years for count 2, imprisonment for 7 years for count 3, which was the stalking count, and then an additional 2 years for failure to appear. So that's how we add up to the 17-year recommendation. Now, judges are not necessarily bound to accept the recommendations, and it is also somewhat common for terms to run concurrently. So instead of 17 years, it would actually only be the maximum recommendation would be 7 years. So if the judge was to decide that was an appropriate penalty, then potentially that could be what this defendant would face. I think that there would still be an appeal on the constitutional question.
To say to the appellate court, did this trial court get this right, that this is not First Amendment protected
Exactly.
speech?
And this is a crucial question because we're talking about a police officer who is a public official. And one of the core reasons that we have protections for free speech is to be able to criticize public officials. And so if a citizen believes that a police officer is racist or has some other character defects, we have a right to tell other citizens about that. It seems like in this situation, perhaps the complaining citizen brought the officer's spouse into it, which may change the calculus a little bit. But ultimately, when we're talking about protected speech, typically, unless someone gets into what's considered to be fighting words or obscenity or advocacy of illegal acts, then by and large, you're allowed to say what you want to say. And so I was kind of surprised that at least on the harassment charges, that this might be considered a crime as opposed to protected speech, because it doesn't appear to be that these were threatening statements so much as they were just unwanted and highly critical of the officer and perhaps the officer's spouse. So if the issue posed to a court of appeals is whether harassment is an area of speech that is not protected by the Constitution, I think that's a very solid position for the defense to be in, saying that I'm not aware of any court that has ever said that harassment is the same as a threat.
Yeah.
So true threats not protected. As far as I know, harassment would be considered protected.
Yeah.
And so, I think based on the limited information that we have that there's at least a reasonable grounds that maybe the convictions for harassment might be overturned. Stalking may be a different issue.
Yeah, I get that. And, it's crazy when you think of the terrible things people say online about, I think particularly female politicians, but really all politicians, what they'll say about journalists whose work they're just reading that's out there. The sort of statements that are terrible. And I imagine if a jury was looking at this, they'd go, yep, that's harassment. They need to go to prison for 4 years. That's not the America I want to live in. I find this a little bit troubling, as much as I hate that sort of online discourse.
I think we're confusing. I think we're confusing the term harassment. Okay, there's harassment where I say, hey, how you doing? Your team lost last week, blah, 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 And then there's harassment as defined by the criminal statutes. Yeah. Which is what this is. And by definition, if it's a crime, then it's not protected.
Well, I would say I don't know that I would agree with that at all.
Criminal conduct is it's already being policed by the state. They're already saying if you do this, if I meet these elements of harassment, that's a crime.
But if the crime is entirely composed of someone's speech, that's where the question, the constitutional question comes in.
The issue then becomes whether that statute that makes harassment a crime is unconstitutional. That's the question. As far as him not being threatening, I got to push back on that because one of the things he would say was he's ready to do something unspeakable. He was ready to end their lives,
okay,
not his life,
that is
their lives.
Yeah.
If you've watched this thing about James Garfield that's on Netflix right now, if you haven't, it's Death by Lightning, really good. It's about some crazy guy who assassinates President Garfield, and he's like saying stuff like this. I say if it rises to the level where it met the elements of harassment, the crime as defined by Missouri law, then it's not protected First Amendment speech. Threats are not protected First Amendment speech. Shouting fire in a crowded movie theater, the classic example isn't. Saying this police officer, I had an interaction with him and I think that he's racist, that is protected.
Yeah.
Okay? But once you cross over into threatening and rising to the level that was risen to in this case, I can see how this would. Now, having said that, 17 years is in my view extremely excessive for this.
Yeah, and I know your view is that he's not going to see 17 years. The judge will not go with the full recommendation.
Yeah, and if he doesn't have priors, and we don't know, but he will do a fraction, probably less than half of the 7 years if they run it concurrent. So,
Dave.
Yeah, so just to respond on the true threats question. So if in fact the court made a determination that the defendant had actually threatened to do harm and had the apparent ability to do so, then that's when you get into the category of unprotected speech. But the U.S. Supreme Court quite recently has reiterated that you've got to be really careful about determining what constitutes a true threat and what is just someone blowing off steam. So there was a case just a couple of years ago with a guy who was a fan of a musical artist and was sending a lot of unwanted communications to this artist that she perceived as being threatening. And Colorado had a law that says it's illegal to send messages that someone perceives as threatening. And the U.S. Supreme Court said, no, it is not sufficient to say that somebody else perceives this as a threat. You actually have to evaluate whether the statements would have put a reasonable person in fear of actual injury? And did the person who is making this statement act with reckless awareness that them saying something like this might cause somebody to be afraid? And so that's kind of the standard that we're working with constitutionally. And again, not knowing the details of this particular case, it's possible that there was a true threat involved, in which case criminal prosecution would be valid under the Constitution. But that's the question that I think would need to be answered.
These are good questions. And what I love about talking to smart lawyers is they see things through different lenses and have different ways of looking at it. But Eric, you're potentially the tiebreaker here. What do you think?
Well, I think it's safe to assume that the defendant did not have any convictions, because otherwise the jury would not have been able to render the decision. And of the many, many, many arrows in the judge's quiver is something known as shock probation. He can sentence the defendant to 90 days with the Department of Corrections and then suspend the rest of the sentence pending.
See if he can get his mind straight.
Right. Yeah. And anybody who thinks that 90 days in the Department of Corrections is soft time has never done it, has never known anybody who's done it. Yeah. Now, if you're a repeat offender, you just spent half your life there, it's no big deal. But I know I would be scared to death if a judge sentenced me to 90 days in the Department of Corrections.
Oh, for sure. I would never write another harassing message again. I assure you all. I would hang up my typewriter at that point. So, Eric, well, thank you for that. In our final, we got a couple minutes left here. I want to talk about something that piqued my interest, which is everybody in Missouri seems to be talking about Air Bud. Now, I blame St. Louis Public Radio's Jason Rosenbaum. He wrote the first story that referenced this 1997 Disney comedy in the context of Missouri's new congressional maps. Two things you wouldn't think would be in the same hemisphere. The reason it's relevant is because of a ruling by the referees in the movie Air Bud. This dog Buddy, they try to bring him onto the court to join the basketball team. And the refs swiftly overrule any objections. Here's their quote: "Ain't no rule that says dogs can't play basketball." So I got to ask this panel of lawyers here for your opinion on this. If there ain't no rule, does that mean that dogs do, in fact, get to play? And by that stretch, does that mean that they can, in fact, redo these congressional maps? Dave, we'll have to keep this relatively short.
I think I can do this. So the general rule in states is that the state government has plenary authority. They can do anything that is not expressly forbidden by the state constitution or the U.S. Constitution or federal law. Missouri, up until 1945, had a provision in their constitution that allowed for mid-decade redistricting. The state would conduct its own census, separate from the federal decennial census, and after that, they would then redistrict the congressional lines. However, the citizens of Missouri removed that provision from the Constitution in 1945. And the question is, having once had this express permission and then removed it, does that mean that the voters intended to eliminate the discretion to redistrict, or is silence just silence? I would say, as a matter of constitutional law, silence has to be silence. That even though it was removed, we did not impose an express prohibition on mid-decade redistricting. And I hate to say this because I think this is a horrible idea. But at the same time, just because I think it's a horrible idea doesn't mean it's unconstitutional.
So in our final 20 seconds here, Eric, if there ain't no rule, do dogs get to play basketball?
No, they don't. And I'll also say, in terms of full disclosure, I volunteered to be on the congressperson's legal team to bring an action contesting this. I just think that it is beyond the pale. There's only 2 African-American representatives, and they've taken away one of them.
Wow. And then, Jennifer, yes or no, do dogs get to play basketball?
Oh, boy.
Well, we're out of time. That was Jennifer's one word. Jennifer Joyce, thanks for joining us today. Eric Banks of Banks Law, thank you. And Dave Rowland of the Missouri Freedom Center, thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.